The leak of a draft Supreme Court opinion.
The Supreme Court.
The court that dark money built.
Breaking news at the Supreme Court.
The landmark Roe v. Wade case.
A woman's constitutional right to an abortion.
My body, my choice.
And Leonard Leo, who really is responsible for helping Trump fill the Supreme Court.
A Supreme Court decision with dramatic consequences. The justices ruling 5-4.
You look at the decisions like Shelby County that attacks voting rights, and then you look at the dark money cases like Citizens United. It's not just us.
The court is not in order. This is Senator Sheldon Whitehouse, and welcome to Making the Case. Season 2, we are back in a new Congress, and we face the continuing problem of special interest influence in the judiciary, particularly on the Supreme Court, and particularly in this administration, where so much depends on a Supreme Court that will stand up against improper political pressure from the executive branch. And it's in that context that we look at something kind of technical, which is amicus briefs. Amicus briefs written by groups that come in as an amicus curiae, a friend of the court, and their job is not to be a party, but just to provide information to the court, and in modern days, to try to influence the court. And we'll talk about how they influence the court and how they can do so hiding who the real donors and influencers are behind them. Most of them are front groups, or at least a lot of the ones in the really bad decisions. Today, I'm joined by law professor Larsen from the William and Mary Law School and law professor Paul Collins from the University of Massachusetts Amherst. So we will go on to that. We've got two wonderful experts and looking forward to the conversation. Professor Larsen, welcome. Delighted to have you here.
I'm happy to be here. Thanks for inviting me.
And Professor Collins, thanks also.
I appreciate it immensely.
Let me start with Professor Larsen, just like the basics for people who aren't familiar with all of this. What is an amicus curiae and why are they in court?
Yes, so it's Latin for friend of the court. That's what it means. And by the way, there's multiple ways to pronounce it. I was always taught amicus, but some people say amicus, and Justice Breyer says amicus. So there's no rules. But it's an old concept. It's not a new concept. And the original idea was it's sort of a neutral bystander who has no interest in the cause before the court, but makes a suggestion on a point of law for the presiding judge. And actually, it used to be like a long time ago, pre-18th century England, it was just a person who happened to be in the courtroom who was literally a friend of the court, who wasn't a friend of an organization, but just someone who would like help the judge out by pointing out cases the judge might have missed. In America, it's not been like that for a very long time. So in the United States, the amicus curiae is now, as Paul said, it's like a lobbyist, like somebody who has an interest in the case, but is not a party to the case. And they file briefs informing the court of their interests. Sometimes they just say, hey, whatever you do, don't rule this way. And sometimes, which is what I'm most interested in, they provide additional facts to the court that aren't in the record, and they're trying to sort of lend their expertise to the court. But it's Latin for friend of the court, used to be neutral bystander. Now everybody knows they're motivated briefs now.
Yeah, and very often filed in coordinated flotillas, not just one by one.
That's right. I've called it in the past an amicus machine. There's a coordinated system to make sure you get the right voices in front of the court saying the right things. And none of that is accidental.
So just real quick, what does the amicus machine look like? What are its essential elements?
So I think there's two big parts to it. The first one is like a wrangler. So someone who literally recruits other interested parties to say what they think would help the court make the court's decision, I guess, more fully informed is the most generous way to think of it, or just to make sure that the court doesn't go in a way that is hostile to the interest of the party or the interest of the organization. So the wrangler is the recruiter. And then you have an amicus whisperer, who is the person that is editing, maybe in the strongest form, or at least softly influencing the content of the brief. You know, it would be great if we could get a bunch of doctors that would say that mifepristone does this or that. Like, that's a whisperer, it's a person that keeps everybody on task, like keeps everybody on message.
So in my terminology, the wrangler rounds up the front groups who file the briefs, and the whisperer tells them what it is that would be most helpful for them to say.
Right, exactly.
Professor Collins, what do judges think about this operation? How switched on are they to the fact that it's a machine, and how do they consider amicus briefs?
Yeah, so there's pretty substantial evidence that amicus briefs matter in different ways. Perhaps most obviously, they have a huge influence on whether or not the Supreme Court takes cases, but they also influence the outcomes of cases, the votes judges cast. I've demonstrated in my scholarship that judges borrow language from briefs, and that might mean, they help shape their judicial opinion or actually form legal doctrine. One of the most significant findings about this is that not all briefs are created equal, and sort of not all litigant support of amici is equal. So we know, for example, that litigants that have more briefs on their side, they tend to come out ahead. But this is especially true if they have the right amici. So if they have these elite, powerful interest groups, and if the briefs are filed by these elite, powerful lawyers. So judges, I hate to say this, I think judges have a slightly naive view of amicus briefs in that they don't quite yet see the very tangled web that's going on in the amicus practice, especially in high-profile cases. But it's conversations like this, and it's scholarship like Professor Larsen's scholarship that's going to expose some of this and hopefully get judges to think a little bit differently about just how independent amici are from the parties that they support.
Yeah, that takes us really to the heart of our conversation today, because sometimes the amici who are filing briefs are actually connected to a party in the case, and sometimes amici who are filing briefs in a case are connected to each other in, as I said, flotillas, and the disclosure requirements that the Supreme Court has for explaining who you are for real and who's behind you are pretty terrible. So in terms of the connection to parties, you have done some research about special interests who helped actually fund amici, who came in pretending to be neutral, but actually for the party. Tell us about that case.
Yeah, so I filed an amicus brief with a great organization called Court Accountability in Epic Games versus Google, which is an antitrust case. But where I came into the picture is Epic Games recognized that the amicus effort on behalf of Google probably was going to involve Google-funded amici or attorneys that had these connections to Google. And they probably didn't have to disclose that because, as you said, the funding rules are really, really easy to evade. In this context, it's basically, did Google fund the direct financing of the amicus brief? And the answer to that question is almost always no, because you can easily evade that, for example, by giving money to a general operating fund. So Epic took a really unusual step, and they linked their consent to file amicus briefs to a condition that the amici disclose any money that they received in the past 12 months from a party or another amicus. Not surprisingly, this ruffled a lot of feathers, and only 2 of Google's amici consented. The other 17, they refused to disclose, and several of them actually chastised Epic Games for this condition to the court. So since 17 of Google's amici were going to refuse to disclose any connections, we decided to do it for them. And here's what we found. We found that 11 amici appear on Google's published list of interest groups that receive substantial funding by Google's government affairs and public policy team. More than a dozen scholars and experts had past or present financial ties to Google as consultants, as grantees, as award recipients. The counsel for Google's amici have represented Google in more than 200 federal district court cases combined. None of this had to be disclosed. And so with court accountability and using public information, we were able to disclose this to the court. And as you've pointed out in your work, Senator Whitehouse, this case, Epic Games versus Google, is not unique. Google has employed this flotilla before.
And if you're not Google, the same thing can happen in other cases. In the Bruin case in the Supreme Court, which was the gun case, 12 of the amicus briefs were filed by people or institutions who had received total millions of dollars from the NRA, the National Rifle Association, and the so-called experts in some of these amicus briefs were also NRA-funded legal scholars. And the NRA was not the technical party. It was the New York State Rifle and Pistol Association, which was an associate. But all of that should have been, at minimum, disclosed, and none of it was. Let's talk for a minute about where the relationship isn't just with the parties, but that there's a group that wants to come in, a group of amici, and they want to make a case in a flotilla because that signals to the justices that this is important to their big donors who the justices tend to know. But my favorite miscreant behavior in all of this was in a case called Moore v. Harper, which was about state legislatures' ability to overturn elections. And a group showed up in that called the Honest Election Project. And it filed a brief in that name. What's interesting is that the Honest Election Project actually does not exist, except as the fictitious name under Virginia law of another entity called the Judicial Crisis Network. But it doesn't disclose that it is nothing but a fictitious name for the Judicial Crisis Network in the brief. And it further doesn't disclose that the Judicial Crisis Network spent millions of dollars helping get the Trump appointees confirmed with political ads in battleground states and is effectively run by Leonard Leo, who's behind the whole court fixing operation. So that would be pretty relevant to the public trying to understand what the motivation was for the brief, and none of that was disclosed. That's the kind of stuff that ought to be disclosed, don't you think?
This idea, this neutral sounding name is rampant. So I've pointed out my favorite example is, I guess, the American College of Pediatricians versus the American Academy of Pediatricians. And the American College of Pediatricians is a socially conservative group that was founded to protest the adoption of children by gay couples. But you wouldn't know that from the name American College of Pediatricians. And I think the public needs to know, but I fear for the law clerks. I mean, as a former one myself, like it's very hard to know whether the factual assertions you're reading are coming from a reputable player. And so I think a value to these disclosure rules and strengthening them is not just a value to the public, but a value to the courts themselves.
And one of the things that these flotillas tend to do, at least in my view, is to help move legal doctrines that help the interests that are behind them, doctrines which have very often been cooked up by special interest funded entities like a program at a law school, for instance. And then they become the vehicle for taking the doctrine and pressing it on the court in sufficient numbers that the court could be led to believe that this actually is a thing and not just the product of a special interest doctrine factory. And it creates a kind of multi-voice echo chamber. And then the Supreme Court accepts that doctrine, and suddenly it is now transmuted from a special interest theory cooked up in a special interest funded greenhouse, basically, and through these multiple briefs to provide a lot of echo, and then boom, next thing you know, there's the Supreme Court using the doctrine. Do you see that as well?
Yeah, so I saw this in the Epic Games case where, for example, a lot of the authorities and the experts cited in Google's amicus flotilla, they had financial ties to Google themselves. And so it's this astroturfed effort that clerks, as Professor Larsen said, and judges are probably not aware of, because these savvy lawyers and these elite interests are able to fund not just amici, but they can fund scholars, and they can put on conferences, and they help build credibility for legal theories that once might appear pretty fringe, but all of a sudden you see the theories published in law reviews, you see conferences about the theories, you see them popping up in amicus briefs, and it seems that the law is kind of developing on its own, when in reality it's being orchestrated behind the scenes by, who knows who's doing it.
Yeah, there's a whole judicial influence ecosystem that begins with the creation of the doctrine and then moves out into more or less fake conferences, and then becomes at least fake real enough that it can get into amicus briefs. And then if 20 amicus briefs are talking about it, then it can look to people like it's actually a thing and not a product, like unitary executive theory or repeal of Chevron deference. All of that began in doctrine factories and ended up in Supreme Court opinions.
I would just add, I think that word doctrine really matters to people who've been through a legal education. And so having arguments that are a little bit creative or, as you say, fringe, that's nothing new in the law. But using the word doctrine to package them, that's a word with power, because it's saying this is law. This is something you have to do. This is something you have to study for the bar. And then a whole generation of lawyers, like people who are educated in my classroom, they learned this idea as a doctrine, whereas the generation before hadn't learned it that way. So I think of the major questions doctrine.
Yep.
That argument that Congress doesn't delegate high stakes issues away to agencies, that argument is not new, but calling it a doctrine, that makes it different. That makes it a thing. And the word doctrine to package that argument has been used by amici and also interest groups on social media. There's just sort of a new way that we are making something a doctrine.
And nobody is really putting in the effort to look behind the fabrication of, for instance, the major questions doctrine and tracing it back to the, for instance, fossil fuel funded program at the university and the fossil fuel funded professor at the university who cooked it all together, and the fossil fuel funded program where they held a conference and it was discussed. And so that your students sitting there don't know the backstory of the doctrine fabrication. It just pops up as if it's real.
I think this is precisely part of the problem, which is oftentimes it's the elite interests that are able to fund all of this. But in order to uncover what's going on, you need a lot of resources to do that, right? This is basically, the type of investigative journalism that groups like ProPublica do in order to figure out the justice's ties to elite patrons, for example. But it's not necessarily the easiest thing in the world to expose all of this.
Yeah.
And so by requiring, some basic levels of transparency in amicus briefs that the Judicial Conference is considering, it will get us a little bit closer. But right now, it's fighting resources with resources. And a lot of the folks that are trying to expose this it's a type of David and Goliath thing.
So let's move from doctrine to facts. You mentioned, Professor Larsen, in your opening that very often the purpose of the amici in coming into the court is to try to present facts to the court that will help inform its decision. And you've written an article called The Trouble with Amicus Facts. And I've written a law review article about fake facts that the Supreme Court seems quite comfortable to adopt. Tell us about, first of all, how much deference the Supreme Court is entitled to with respect to fact-finding versus its lawmaking function, and what is the trouble with amicus facts?
This is an interesting question because a lot of lawyers have come to me and be like, what do you mean the Supreme Court finds facts? They don't find facts. They declare law. Like finding facts happens at the trial court. And
those were the days, huh?
Yeah, that instinct is understandable. But there is this old distinction between so-called legislative facts and what are also called adjudicative facts. So a legislative fact is a fact about the way the world works, as opposed to a fact that might go to a jury about who did what, when, where, why. And adjudicative facts are not supposed to be found by the Supreme Court or by an appellate court, but legislative facts, they're exempt from that rule. So there's nothing procedurally wrong with an appellate court finding facts. I think what's happened, and this is what my paper is about, is there's a hunger for these facts about the world that has grown with our technological change and our ability to look things up on our phone now. And the tool that we're using to accommodate that need is an old tool. It's this amicus tool that we haven't actually regulated in a really long time. So it's a bad fit. And you end up with these groups that don't have to disclose very much about who they are, making claims of expertise to the court. And I'll tell you this, when I first looked into it, I asked my research assistants, I want you to list for me the authorities that the amici find. And I remember the research assistant, this is like a decade ago, saying to me, actually, Professor, they don't cite authorities. They're just asserting facts. And I was like, what? That can't be right. But it's true. I think the court is using the amici almost like an expert witness at trial. Let me find out about the effect of video games on juvenile brain development. Oh, here's a brief for that.
With the very important difference that an expert witness at a trial is subject to cross-examination if they can't stand behind their judgments or if they're shown to have a huge conflict of interest. So there's a test in real life of the facts, even from an expert witness, as opposed to up at the Supreme Court, where it's the last call on the train and nobody gets to review any facts that they find.
And that is exactly the trouble with them. I think the trouble with them is that they come in at the 11th hour and they're untested. And so you end up with facts that are shaky in their reliability or have been paid for by someone who's motivated. And none of that comes out because there's not enough time for it to come out.
By the time anybody reads about it, the final decision is what they're reading.
Exactly.
And one of my real objections here is that the tolerance for the Supreme Court has grown for absolutely false facts. I mean, the problem you mentioned would be real even if you had a Supreme Court that was doing its best to be honest with its legislative facts. But when, for instance, in Citizens United, they found that all of the new money that they were unleashing into our political systems would be transparent, that people would know who was the donor, that there wouldn't be any dark money in the system, has been just completely exploded by the billions of dollars in dark money that have, in fact, poured into the system. They couldn't have gotten to the outcome they wanted without that finding that there would not be dark money, that the dollars would be transparent. And instantly, the world rebuked that with floods of dark money, proving them indisputably wrong, and they haven't budged or reconsidered. So these legislative facts, even when indisputably false, can be awfully damned sticky.
Yeah, it's particularly problematic because the justices and their clerks, while they're great legal minds, they're not particularly trained to assess a lot of these facts, right? There's not a social scientist on the court vetting these facts. And so a lot of times what's happening is they're just accepting facts that mesh with their ideological preferences and get them to the predetermined outcome that they were headed towards, rather than actually taking a step back and assessing something.
And Marbury v. Madison, it's the province of the court to say what the law is, but it has no particular specialty as to saying what the facts are compared to, say, Congress, which deals with legislative facts all the time, hence the term legislative facts. Well, let's take a look at kind of the solution to this as it's percolating through the judicial conference. First of all, what is the judicial conference? And second of all, where are we in the judicial conference trying to look at what one of the judges called the real power behind the throne of an amicus flotilla?
So the Judicial Conference is the governing body, and they're considering a change to Appellate Rule 29 that covers the basic aspects of amicus briefs. And the policy towards amicus briefs, it's very, very liberal. Basically, you just have to obtain the permission of the parties in order to file. And if that's not granted, which it almost always is, then you ask the court for its permission, which it usually does. And as it relates to what we're talking about, as long as the amici is not taking direct money from a party to litigation, they really don't have to disclose anything. And so we know that this is very, very easy to evade. And so the Judicial Conference is considering—
They haven't caught up to the amicus machine.
No, that's exactly right. I mean, that's why it's so important to have this conversation now. And I'll be honest, it took me a little bit of time to come on board that all of this was happening. I was first alerted to it before Professor Larsen published her excellent piece. I sort of had some people telling me that this might be going on, but I thought it might have been a little bit in conspiracy theory territory. But
until we got our hands on the Bradley Foundation email to Leonard Leo about how they had money to spend to coordinate briefs, actually in Friedrichs and Janus.
That's exactly right. That's exactly right. I needed to see the evidence. The evidence is overwhelming. And it's great, that the Judicial Conference is thinking about it now. One of the changes would require an amicus disclose whether a party or its counsel contributed in the last 12 months more than 25% of the total revenue for the previous fiscal year. That's a welcome change. 25% might be a little high, but that's fine. They're looking at closing a member loophole. So right now, if you're a member of an organization, you don't have to disclose. And then I think Professor Larsen mentioned earlier, a lot of these amici are sort of astroturf fake organizations. I actually remember more than 20 years ago when I was doing my initial research on amicus briefs, I came across an organization that I never heard of, and I don't remember the name of it, but it was something like Americans for a Better America. And it turned out being all of the major oil companies like Exxon, Mobil, and things like that. So this has been going on for a while. So that requirement would basically provide a little bit of transparency, talking about the identity of the amicus, their history, the date of creation, if they were created within a year, which would help open up the books for judges and their law clerks as to exactly what's going on.
The Judicial Conference work has seemed to try to divide the world into two groups. One is amici who are connected to a party, like the groups that were funded by Google when Google was a party. And the second is basically everybody else. And the change in Supreme Court litigation where the party really doesn't matter any longer. The party is a figurehead chosen by the litigation group to get standing. And in the case of Friedrichs and Janus, actually put on the litigation group's payroll. But the real party, the real force and impetus in the Supreme Court case is the litigation group and the amicus groups that surround it, which swap position. So that in Friedrichs, there was a group that was litigating group, which became an amicus in the successor case of Janus. And in Janus, the case that was litigating group had been an amicus in the case of Friedrichs. And it's this little cloud of special interest front groups. And what do you think the chances are, Professor Larsen, of the Judicial Conference getting that at this point?
I don't think this is rocket science, or indeed that it needs to be quite so politically divisive. I mean, the best disinfectant is transparency, right? Disclosure. So we all know that when you read a review online and it's been paid for, you discount it. And when an expert testifies and he's been funded by the NRA and he's testifying about a Second Amendment challenge, you disclose that, and that limits the credibility. I don't think of this as revolutionary, and I don't necessarily think it needs to be partisan, honestly. I think it's just about updating the ways that we're educating courts to reflect the modern reality.
And some of this is pretty obvious. I'll close out our conversation going back to Americans for Prosperity Foundation versus Bonta, which was a case that allowed 501c3 tax-exempt corporations to hide from the state government who their big donors are. And what the court didn't notice in that is that the current state of the art in politics is that you have a 501c3 nonprofit that is tax deductible. You have a 501c4 that can spend money in politics, buy ads and things like that. And the two have the same offices, the same staff, the same address, the same donors, overlapping board members. In the AFPF v. Bonta case is the Americans for Prosperity Foundation, which is the C3 for guess who? Americans for Prosperity, the C4 that is the big political battleship of the Koch brothers' political influence operation. And even in that case, where they were able to cook up over 50 front group briefs to come in and show the justices, hey, this is a big one for us, even then the court decision didn't reflect any connection whatsoever of the AFPF case and the political influence operations of the folks who are behind the flotillas. This was the biggest flotilla I at least have ever seen. When you're north of 50 at the cert stage, that's a hell of a performance, and it's one that the justices noticed. So much appreciation to Professor Larsen and to Professor Collins for joining us. They have studied this very hard and very carefully. This is one of those areas where if you're not watching, the special interests will pull a fast one on the rest of us. So thank you both for your work. And this has been Making the Case.